So, I'm Ioanna Tourkochoriti, and I teach at the School of Law at NUI Galway. And I'm delighted to welcome you on this panel on theorizing comparative rights jurisprudence. So this panel will draw theoretical implications from the differences in understanding and interpreting rights in various legal systems. Legal systems express deeper ideas on the role of the state in realizing and protecting basic rights and freedoms. And our presentations will discuss the development of rights theory in various states, and they will discuss also the philosophy underlying conceptions of rights as it emerges in legal reasoning in court cases from various jurisdictions, national and supranational. And also our presentations will enlarge the focus of the analysis by discussing similarities and differences in the conceptual architecture of rights and what this means in relation to the positive obligations of states to realize these rights. So we will start with Helge Dedek, who is Associate Professor of Law at McGill University Faculty of Law, and he is also the Editor-in-Chief of the American Journal of Comparative Law. I think we have prepared presentations for 15 minutes, and then we will have a discussion. And I think the best practice is for you to post if you would like to ask a question in the chat, and then I will just ask you to unmute yourselves later on and ask your question and participate in the discussion. So Helge, we are delighted to have you on the panel, please.
Well, thank you so much, Ioanna. This is really fun, and thank you for putting this together and inviting me here. Glad to see you, glad to meet those who I don't know yet. I also see that Mary Kim is in the room and Rick Hay, but all cameras off and microphone off. But if that is really you, it's great that you're here. So in the program, you saw that the title of this short presentation, was when rights became subjective, 200 years of subjective rights. That is indeed the working title of a book that I've been working on for a while now, and unfortunately I haven't really managed to finish it. I just, after all this years, still need to learn to be more jealous of my own time. Out of sense of obligation, I always try to deliver all the other things that I'm invited to do more or less on time, and then what I really want to do sort of takes the back seat. It also reminds me that I have to give my publisher the annual call whether the project is still on and they're not pulling the rug from under me because they have a time is of the essence clause in that contract. Fortunately, when it comes to legal history, time is not that much of the essence as is the case with other projects. So here in that context, just a couple of specific aspects of that book project. It's the project in comparative legal history. I'll say a couple of words to that later. It's on the development of rights theory in Germany, France, and also with a view towards England over a period of 2 centuries, beginning in the mid-18th century and concluding with the dismantling of rights theories in Nazi Germany. The main focus, however, is on the, if you will, long 19th century. So the question, when you read the title of our panel here in the program, Theorizing Comparative Rights Jurisprudence, the question might be whether we haven't talked enough about rights. There's so much literature on rights discourse, rights talk, and of course, rights critique that is as old as the theorizing of rights, going back to Marx in the 19th century. We know of the theoretical, the offerings, the theoretical offerings dealing with rights and the problems with rights from classical liberal theory to the classical indictment of rights. For example, Charles Taylor, sorry, it's COVID. People coming coming home from school. Charles Taylor, who identified liberal rights thought with the malaise of modernity. So our fundamental problems of living in an atomized society, being in these monadic bubbles that keep us from forming real relationships with each other. This is closely connected to this concept of rights and individualism in liberal thought. So in how far do we have to rehash this, and how far could comparative legal analysis here add anything to this discussion? I think that this is a very opportune moment to talk about this, because I think the way in which approaches to individual rights differ in different societies and different cultures is being showcased at the moment in a dramatic way by the pandemic. Just take the quote by Canadian anthropologist Wade Davis in his article in the Rolling Stone magazine, Unraveling of America. He says, the American cult of the individual denies not just community, but the very idea of society. And you don't have to buy into this very pessimistic view, but I think really, even when you're critical of an overly communitarian approach to rights, and I'm, with my German background, I'm very distrustful of an overemphasis of community. I think that there is something going on here that is fundamentally different from what we see in other societies. And the way in which people respond to the imposed restrictions, the extent to which they protest, and the way they voice their protest, all of this, these are expression of different rights cultures, if you will. And the comparison of those seems to be, to me, a very interesting and promising field, especially when you then, okay, did you hear that too?
Yes.
But it's reassuring. So what I was trying to say is that I think there is potential for this kind of research, especially when you want to push past the stereotypes. And history seems to be one way of trying to contextualize these kind of claims to different cultures of rights. And I think that's what Ioanna's work and Peter's work is about, taking concrete rights and contextualizing them historically, looking at how different jurisdictions come up with different concepts of rights. My work is not about a specific right. It's not about freedom of speech, freedom of expression, or freedom of religion. It's really about the theory of rights, and it especially focuses on the language of rights, more concretely on the language of subjective rights. So that is a specific standing expression that we encounter in continental legal orders. In French, it's droit subjectif. In German, it's subjektives Recht. And my project follows methodologically the approach of Quentin Skinner and Reinhard scholars, Reinhard Koselleck and scholars who follow this school of thought, that assumes that when there's a certain terminological creation that gains currency at a certain time, that this tells us something also about what's theoretically going on and ideologically. There is a lot of research on rights that does not pay heed to this language, that finds subjective rights avant la lettre. Yeah, you probably all know on this panel the work by Brian Tierney, Michel Villet, theorize that subjective rights were born in the Middle Ages. There has been a long tendency to kind of push further back the invention of rights. But of course, the language of subjective rights is not used in the Middle Ages, is not used in Renaissance scholarship, but this is something that really is being developed in the 18th century and then gains popularity in the 19th century. And this is the main focus of my study. So how is this now a comparative project? It started out really as a project that was triggered by the sense that even in this day and age, a lot gets lost in translation. I have a colleague at McGill who's very highly regarded private law theorists in the common law world in the Commonwealth, Steve Smith, and he also writes a lot about rights, and he comes to me time and again, or came to me time and again, asking me, well, what does subjective right mean? What does it's difficult to as a Anglophone theorist, especially in an analytical tradition, to understand what this is supposed to mean. And looking into this, I saw that there is a tradition in English rights scholarship that looks comparatively to the continent to conceptualize or to perceive better the expression of droit subjectif as some sort of tautology, yeah, as something that the English language does not need because of the difference between rights and law. However, the poverty of the continental languages, as I've read, necessitate to put the qualifier there. If use, if recht, if droit means right and law, then you need to qualify whether you're talking about it in a subjective or objective quality. And what really then inspired me to go further with this was an article by Thomas Maudner, a very learned article about the historical or origin of rights that especially focused on the way that Kelson's work was translated, because the translation of Kelson's work deals with something called subjective law, introduces, so besides subjective right and objective law, introduces something in the middle called subjective law. And Maudner says that is a contradiction in terms, that is an impossibility. And I thought it's interesting because for Kelson, this is such an important step in his theory to say how he wants to get rid of subjective rights as a category and just think of objective law that is subjectified in certain instances. So subjective law to me seemed a prudent choice of translation. However, we see here an instance of translating not only from one language to another, but also from a way of thinking about rights to another one, from the formalism of the continental type into an Oxford style analytical jurisprudence. And to me, it's always fascinating how things get lost when you try to translate not only language, but also from legal system or from other epistemological systems that gain or that reign in a certain geographical area. So that is, hey, hi, my son just came back from home. Thank you. Let's put it down here. Thank you. Yes, can I go? Thank you. Sorry. This is just it's the realities of this COVID. So I'm running up to the 50 minutes already. So to cut this short, so in this respect, it's a project of comparison that just compares different ways of conceptualizing rights. In how far is this now specifically also a legal project? Because the literatures that I mentioned, especially tyranny in recent years in the English-speaking world, Seagrave, these are historians, these are political scientists and theorists, these are political philosophers. These are not jurists writing about this topic. What I find is missing in these stories of of rights is the particularly juridical aspect. And you see this particularly in the way that the 19th century is perceived. Those who just are interested in the philosophy of rights, or specifically in natural rights, translating, morphing into human rights, so the universal concepts, they often will tell you that the 19th century is sort of a barren period, where rights, as one historian of rights has put it, hibernate. And I think that might be right from the perspective of these disciplines, but they have a bit of a blind spot for the particularly juridical aspect, in the sense that this is a very fruitful area for legal theory that is reappropriating, if you will, a language of rights that was legal in the first place, that was from Roman law thought transferred into political philosophy, that expressed itself through concepts of property, of contract, of rights, and that now becomes retransferred into legal discourse during this time, becomes re-juridified, if you will. Legal science at this point, focusing on positive law, makes rights the cornerstone of the positive systems, despite the fact that neither in Roman law nor in classical common law these were pivotal concepts, and makes rights part of everyday legal syntax, if you will, and operationalizes it. Yeah, and I think this is laying the foundation for the role that rights could play in the 20th century. But before we come to this success story, if you will, of human rights in particular and constitutional rights in Europe in particular, there is a moment when, towards the end of the 19th century and the beginning of the 20th century, rights are in decline with the rise of the social, to use Duncan Kennedy's famous expression. There is also a surge in rights critique, and this then of course, in my particular narrative, leads to a reflection on the dismantling of rights on the threshold to totalitarianism, especially in Nazi jurisprudence. And the project started a bit with Kelsen, and it ends with Kelsen in this respect, because Kelsen, strangely enough, also speaks out against rights, and he's, of course, they're in very bad company. Kelsen was an upstanding Democrat and was persecuted himself. And it's a bit hard to understand why he tries to erase rights from his system of law. He has been misunderstood in that respect, and trying to shed some light on this decision is then kind of where the project ends, and this little presentation as well. I hope that has given you a little bit of an idea where I'm going with this. Of course, it's difficult in 15 minutes, and I apologize for the interruptions, but such is life. Thank you.
Excellent. Thank you, Helge. I think there are many common themes, and we will be coming back to many of those ideas. And also, debates that you have mentioned, I think, have been recurring in the course of intellectual history. So many, I'm thrilled because we have so many ideas to discuss later on. So now we will hear Peter Danchin, so we are delighted to have him participate as well. So Peter is Jacob A. Franz Professor of Law at the University of Maryland Francis King Carey School of Law, and he is also the director of the International Comparative Law Program and the Associate Dean for Research and Faculty Development. Peter.
Thank you very much, Ioanna, and thank you as well for organizing this session. And it's great to be on this panel with both Helge and Talya. I'm looking forward to our conversation. What I would like to discuss today is some work that I actually began about 5 or 6 years ago in a project called The Politics of Religious Freedom. And I co-wrote an article with a colleague, Saba Mahmoud, an anthropologist at Berkeley, who, as you may know, tragically actually died a year or two ago. But we engaged in this research project together, looking at a series of decisions of Egypt's administrative courts involving the rights of Baha'is. And much of this jurisprudence is actually very hard to access because, of course, it's all in Arabic. And we actually hired translators to translate these decisions into English. And this sort of opened up a world for me of jurisprudence and decisions that I've been working on a little bit on and off for the last 5 years, but I'm returning to in a way that I'll describe in a moment. And what we tried to ask in this work was how the right to religious liberty actually functions in the Egyptian constitutional order, and how it compares or differs from some of the other religious freedom jurisprudence, most particularly that of the European Court of Human Rights. And coming to some of the points that Helge made, what really interested us was trying to think about the notion of religious freedom when it's understood not as a relation between the state and religion per se, but as a right, as a relation between the state and an individual subject. And so this idea of subjective rights, of course, is very suggestive to me in this distinction. Of course, having a right assumes a rights holder, and of course requires interpretation of the meaning, scope, and limitations of the right. And so what we were interested in is what this comparative work, and it was fairly amateur comparative work to be honest, but trying to think across systems what this investigation of the Egyptian jurisprudence might reveal. And what we found surprised at least me, I don't think it surprised Saba quite as much. We found more similarity than difference in the reasoning of the courts. That both the modes of interpretation and the kind of reasoning that were employed by judges in the Egyptian courts bore an uncanny resemblance structurally and normatively to the jurisprudence of the European court that most of us are much more familiar with. And we then tried to get to work on why this might be the case. And of course, one might think that in a legal system grounded in Islamic jurisprudence and a long history around questions involving the Sharia, it came as somewhat of a surprise that there was such a strong confluence theoretically in the work that the courts was doing. And we focused then on a question that arises in terms of the modern structure of the right to religious freedom, and what we saw as a paradox. And let me state the paradox, and then I'd like to set it out a little bit with another case. The paradox is that on the one hand, religious freedom claims to be neutral toward religion. And indeed, neutrality is the leitmotif, if you like, of modern discourse, whether it be in moral, legal, or political contexts, right? Secular neutrality is the constant refrain of the field. On the other hand, the more we looked at the case law, we saw religious freedom as a kind of technology of modern state governance. And whether this was in national legal systems or in a supranational system like the European Convention on Human Rights. And we saw the state or supranational regimes deeply implicated in the regulation of religion and entangled in different domains of religious life. So our argument in that article was that this tension between inviolability on the one hand, this claim of neutrality, while this deep entanglement of the regulative power of the state on the other, was in fact internal to the right to religious freedom itself, and actually generates the distinctive antinomies and contradictions over struggles that occur politically over its meaning, justification, and realization. So what got me interested then again in this question, particularly in Egypt, of course, the recent political history in Egypt and the work of scholars done by people like Clark Lombardi and Nathan Brown, looking at the jurisprudence of the Supreme Constitutional Court in Egypt in the modern period. And what those scholars had noted is, again, a paradox. They noted, on the one hand, a kind of liberalized Sharia under state law, and on the other hand, the increasing assigning to Sharia of a powerful normative and public role, particularly under Article 2 of in this case, the Egyptian constitution, but this is mirrored actually in many of the other constitutions in Muslim majority states. And let me just read to you the text of Article 2. For those not familiar with it, Article 2 states that Islam is the religion of the state, and the principles of the Islamic Sharia are the chief source of legislation. Now, I've puzzled over these words for many, many hours. What does it mean to say that the principles of the Sharia are the chief source? And this word source I find deeply interesting, of legislation. Of course, many activists in the modern period see this provision, and particularly the idea of this being the chief source of legislation, as a deep threat to the secular nature of the state and to what we associate as traditional liberal rights and freedoms. And yet here again, we find the paradox that while these arguments are being made about Egypt, in a sense, failing to be what we think of in political theory as a properly secular state, we find an analysis of the Supreme Court of Egypt, Supreme Constitutional Court jurisprudence by scholars as being distinctively liberal, right? So when you look at the work of people who've looked very carefully at the jurisprudence, they repeatedly term this as liberal, and they point to the jurisprudence on Article 2, which in effect requires the court to review and measure state laws against Sharia norms. So this is the context for my interest in this question. What is going on here exactly? How do we understand this dynamic in the modern Egyptian context? And how does it relate to our understanding of the right to religious freedom? So again, like Helge, 15 minutes is very short, but I'd like to set out a couple of theoretical points and then just draw some observations from a case that, again, I discovered through translation, and it is actually a headscarf case or a niqab case. So it's a great case to compare, of course, to the European cases, which I'm sure everyone is familiar with. Of course, classical Islamic legal theory prior to the modern period assumed that the laws of the ruler, in order to be legitimate, had to be consistent with the Sharia. And the difference, of course, was that this interpretive task was to be performed either by legal scholars or jurists, according to fiqh and so on, or alternatively, the ruler could develop rules, statutes in consultation with these scholars. And under the conditions of modernity, in Egypt today, both of these tasks now fall to the province of governmental institutions within the modern state structure, and in particular to the role of the Supreme Constitutional Court. Okay. So again, what I found most surprising looking at this jurisprudence myself with a critical eye was how it structurally mirrors the discourse we find, for example, in European human rights law. And let me try to explain what I mean and then give a brief example. All the modern human rights conventions, and indeed most of the modern constitutional provisions that deal with religious freedom have a recognizably dualistic structure. On the one hand, the first part of this structure is a distinction between religion and belief on the one hand, which is said to be protected absolutely, often known as the forum internum. And on the other hand, the idea of manifestation of practice or manifestation or practice of religion and belief, which is sometimes known as the forum externum on the other, and is said to be subject to reasonable limitation by state law. So in my work, I've tried to explore this dualistic structure and this unstable distinction, what's sometimes known as the belief-action distinction, this kind of co-imbrication of faith and autonomy that seems to animate this idea of an absolutely protected forum internum, and suggested that this distinction is actually what drives modern religious freedom jurisprudence in a way that I'll describe in just a moment. But secondly, there is also a clause in this is in the European system. This is Article 9.2 of the European Convention on Human Rights, which then sets out the specific grounds upon which religious manifestation and practice may be limited. And the two most recognized grounds are public order and the rights and freedoms of others. So in any religious freedom case that you look at, a court essentially has to make two decisions. What is it that falls within the forum internum? What is it that is essentially religious? And thereby, what scope should religion have within the social life of the state? And secondly, what the public order of the state or of the supranational state, say the European community or the European community of states, what that public order consists in and what is regarded as harmful to it. And of course, if you look at the famous cases in the European court, you'll see this dualistic structure running through virtually every case. Now, what we tried to argue in our work was that the first decision the court has to make requires it to take a kind of external normative position, the idea of neutrality as somehow external to religion, which now views religion as subjective, right? And this is where the idea of subjectivity, I think, becomes very interesting. Religion is viewed in various ways, but particularly as subjective in relation to the objective authority of the state. That's really the key point. Having assumed a position of normative authority in relation to religion, this is then justified in a really quite fascinating way in terms of the uniqueness and the necessary nature of religion itself, which is assigned a new position within social life, simultaneously free from state interference, while on the other hand, constrained in a new private, in what we sometimes refer to as the private sphere, right? So in the, I think Winifred Sullivan in her work has really described this quite beautifully, religion as simultaneously tamed is the word she uses, as a matter of private belief, and it's the privatization of religion that is critical in this move, and at the same time free as a matter of authority, as a matter of personal authority, or in rights jurisprudence, individual authority, right? And so we actually see this terminologically, the idea of the Sharia in modernity now as Muslim personal law, right? The transformation from the idea of religion or Sharia, if you like, transformed into within the conditions of the modern state to the term Muslim personal law, this personalization and privatization as being critical to the phenomenon that I'm describing. So that's the internum. On the externum, this now requires the court to switch perspectives and assume an internal position under the language of right, which assumes the initial freedom of religion itself and religious persons, but assumes that this freedom may be constrained by the normative demands of the political order itself and of the rights and freedoms of others. And again, a second paradox arises. By recognizing claims to freedom made in the language of rights, the state simultaneously asserts the power to limit them. So in each case, whether in defining the forum internum or constructing, if you like, the forum externum, a dialectical process of freedom and constraint operates in both spheres. And if we look at the jurisprudence of the Egyptian court, we actually find a remarkable parallel to this kind of reasoning. So let me just give you an example of this, and then I'll conclude my remarks. There was a case in 1996 called case number 8, which was decided by the Supreme Constitutional Court, and it involved a regulation issued by the Minister of Education that prohibited schoolgirls from wearing the niqab in public schools. A father of a child that went to a public school, challenged the regulation after his 2 daughters were expelled from a public secondary school. And he argued that this violated two things. Quite fascinating. He argued that it violated the principles of the Sharia as in contravention of Article 2 of the Constitution, as I described before, but that it also violated Article 41, which states that personal freedom is a natural right and not subject to violation. So in applying the test that I've just described, the court, first of all, identified a number of Quranic verses dealing with veiling, but noted that the jurists have disagreed about whether these require a woman's face and hands to be covered. So that this direct interpretation of the Quranic verses itself, again, was quite fascinating. The court found that the Sharia unambiguously commands covering, right? And that itself was not subject to review or interpretation by the court. But they found that that injunction does not clearly state what it covers in terms of covering of a woman's body. So while they found that the command was certain as to its authenticity, they found that it was not certain regarding its meaning, and thus whether it required women to veil the face. The ministerial regulation, therefore, prohibiting the niqab was not contrary to the Sharia. The court then turned to the second limb and asked whether the regulation was contrary to the goals of the Sharia. So this again is the kind of forum externum test. They sought to identify the ultimate goals of the Sharia, and they asked whether the regulation violated these more general goals, including the expansion of human welfare. And this led to a kind of proportionality analysis that we're familiar with in European jurisprudence. They looked at the various social harms and the various values at stake in different forms of wearing of a uniform, whether wearing the niqab creates social costs, whether it impedes engaging in work, and so on. And again, they found that the regulation was justified under Egyptian law. So I guess to leave you with a thought about this, and again, I don't have time to go into all the complexity of the case, the three questions I would ask in terms of thinking about the reasoning and the judgment that's reached by the Egyptian court here. Firstly, was the judgment liberal or illiberal? Secondly, was the reasoning that the court adopted secular or religious? And again, Hussein Agrama's work on this question, I think, has been deeply informative to me in his book, Questioning Secularism. He calls this the inherent problem space of modern secular power. And thirdly, is the decision ultimately an example of the application of the principles of the Sharia, or is it rather an exception to those principles? And in each of these three domains, there are fundamental ambiguities at play, right? So I might conclude there because I could go into each of these three domains, but my fundamental point is that however one thinks them through, they both bear a remarkable structural similarity to the same ambiguities that we find, say, in the Sahin case in the European Court of Human Rights. And on the other hand, the ambiguities themselves are generated by a strikingly similar theoretical and conceptual set of arguments. And I found that intrinsically interesting in thinking about comparative rights jurisprudence. So I'll finish there.
Absolutely. Thank you, Peter. Extremely interesting presentation. So now I will continue because my presentation has some themes that meet Helge's and Peter's, and then Talya, maybe at the end, you will present also, right? Excellent. So I am also discussing theories of rights and nuances in the understanding of rights that exist in various parts of the world. So even within modernity, even within the discourse of rights that emerged in modernity, different parts of the world have come up with different nuances in how they understand rights. So I'm studying freedom of speech and the differences in the protection of speech between France and the US. But I think it's theories of rights that are underlying the conception in France and the US that can help us make sense of why this difference exists. So I'm sure that you know that in the US, the legal protection of freedom of expression trumps the protection of other values, whereas in France, courts are trying to find a balance between freedom of expression and other values. Some examples are, for instance, hate speech, which is not protected in France, neither is the denial of crimes against humanity. So generally, the harm attributed to provocative or offensive viewpoints is rarely considered in the US as sufficiently significant to mobilize the mechanism of state coercion. But this divergence is also obvious in other areas of speech, for instance, self-expression. So wearing conspicuous religious symbols is forbidden since 2005 in public schools and high schools in France. And also in 2010, the French parliament banned the wearing of the burqa. The French Conseil d'Etat upheld the decision of the mayor taken within his police authority banning the practice of dwarf throwing, a very famous case which I'm sure you all know. And also another interesting example is that unlike in the US, where citizens united and validated upper limits for independent expenditures during political campaigns, France regulates independent expenditures. So as I argue in this book, the divergence in the balancing of freedom of expression and other values can be understood in reference to the broader historical, social, and philosophical context in which jurists operate. And the key ideas here are the role of the government and the understanding of liberty. So those ideas affect how jurists define the content and the limits of the liberty and strike a balance between liberties in conflict. So I engage in this book project in a study of comparative political and constitutional theory, which analyzes theories of government and how they were understood in France and the US since the founding of the two democracies. And I aim to approach critically to different conceptions of republicanism and their significance for rights. So the methodology that I follow is Gadamer's hermeneutics. So identify some ideas which form the ex-ante understanding of the jurist as Gadamer discusses it in a legal system concerning the necessity to protect one liberty over another. So Gadamer describes human understanding as formed on the basis of some prejudices. Those prejudices are preliminary judgments. They don't necessarily have a negative connotation. So the difference in the approach between France and the US, I think, indicates a more profound difference which concerns the imaginary institution of society and of the role of the state on the two sides of the Atlantic. And by imaginary institution, I understand the term the way Castoriadis understands it. So some ideas that I discuss are the understanding of republicanism and how, and theories of rights, of course. So, and this is where I meet Helge's points later on. So although I discuss rights, there are some nuances in the understanding of rights in various parts of the world, even within the philosophical discourse of modernity. So in France, for French republicanism, the quality of citizen is primary and the rights of man make sense only as rights of the citizen. And the state has the mission to realize liberty, I think, for all citizens. And this leads to accepting a wide sphere of government intervention in defining the content and the limits of liberty. And I think this is what we see also in the case of freedom of speech. In American republicanism, the idea of an artificial relationship between political power and civil society is latent, and political power is an artifice in the service of civil society. So American republicanism makes an amalgam between the necessity to protect the common good while respecting natural liberties. So a second idea that I think is very important relates to the understanding of liberty and the conception of natural law that underlies this understanding. So in America, it's crystal clear that the conception of natural law is the modern, which focuses on the negative rights of the individual. In France, the discussion on rights also contains references or resonates with ideas that existed also in antiquity and in Aristotle in particular, right? So in France, I think the dominant conception of natural law strongly echoes also that of the ancients, and in particular the ideas that the natural state of human beings is social, and the social contract doesn't have the role of creating society, but of legitimizing government. So men also, an ancient idea of natural law that exists also in the thought that exists also in the thought of the French revolutionaries is that men and their liberty reach their perfection in society. So although they discuss liberty as natural, it is perfect in society. So they make very interesting combinations between ideas of ancient natural law and modern natural law. And the most important idea that is reflected is that if it is being a citizen that makes a human being, then the rights for the person are those that are recognized to her by political society. So let me analyze a little further some of those ideas. So American thinkers in the years preceding the Declaration of Independence discuss extensively the natural and negative rights of the individual. And to my sense, this discussion was part of an intellectual movement complaining against taxation imposed by the British Parliament to the colonies, which they saw as unfair. And it is this discourse that later on led to the Declaration of Independence in the US. James Otis wrote a lot on this topic. In 1764, he wrote this extremely important book, The Rights of the English Colonies Asserted and Proved, and he contributed to this idea of inalienable rights inherent in the quality of man and citizen. Those rights are inalienable by any government act that would make them positive. And in those, he includes the right of personal security, personal liberty, and private property. And he refutes Blackstone's opinion that those rights and privileges depend on the local charters that exist in the colonies. So he sounds very much like Locke in this respect. And the same discourse, the same idea exists also in Jefferson, in his writings of the same era, pro-revolution, but also later on in his writings around the elaboration of the Constitution of Virginia and also of the federal constitution in the US. And Adams also articulates the same ideas in his works before independence. Rights are antecedent to all earthly government. They cannot be repealed or restrained by human laws. They are derived from the great legislator of the universe. And it is absurd, he thinks, to suppose that men, by entering society, renounce their essential natural rights or the means of preserving those rights. And the end of the government is to furnish the individual who compose it with the power of enjoying those natural rights. So I think that those ideas are helpful for us to be able to make sense how freedom of speech is regulated today. Some ideas are reflected in the current First Amendment doctrine. It is not legitimate for the state to regulate the content of speech. In the US, the right to freedom of expression is protected as a negative right and not as a positive right, in the sense that it would be required by the state to provide rights of access to the media or to guarantee the material conditions that facilitate the exercise of freedom of speech. And along the same line of thinking, the government should not intervene in political debate by limiting independent expenditures by corporations. The idea that some social forces have excessive economic power and thus their speech can affect or even distort the public debate is not important enough to mobilize state coercion. And in this conception of the negative aspect of freedom of expression, the state will not protect individuals from themselves when they engage in modes of self-expression which are considered eccentric by others. For instance, when the wearing of conspicuous signs of religion, of religious affiliation is at stake, and I have in mind the burqa bans and the headscarf bans. In France, at the same time, there was a different discourse on rights. So in the relevant debates reveal a conception of rights as rules which ensure social coexistence, rather than natural qualities of the individual, which would require state action to preserve the individual's self-autonomy and sufficiency. And of course, Rousseau was extremely relevant there, for whom, by creating an ideal social contract, human beings give up all their liberty, but not only they lose nothing, on the contrary, they're even freer than before. So in the civil state, Rousseau writes, natural rights disappear to reappear as defined by positive law, which fixes those rights. So all those intellectual debates that took place around the elaboration of the French Declaration of Rights in the summer of 1789, but also later on throughout the period of the French Revolution. So those debates invoke ancient and modern theories of natural law, and they vacillate between conceptions of artificialism as well as naturalism for liberty, but the social conception of natural law very frequently wins over in the relevant debates. And it's very interesting to see that the participants in the National Assembly in France refer to the situation in America, to the natural rights discourse that was taking place there, in order to distinguish it from France. And they were saying, so they engaged with natural rights discourse in order to dismiss it. Rights do not make sense outside of society, they thought. Theories which were good for America, which was then being born as a nation, were not relevant in France. And this was the case for political actors across the ideological spectrum at the time. And the most striking thinker, I think, is Crenier, who has articulated an extremely interesting theory. So for Crenier, rights do not make sense outside of the social state. In the social state, human beings give up their independence and exchange it with political liberty. In the state of nature, human beings have neither rights nor duties. It is within society that human beings acquire duties, that human beings take on duties, while acquiring equivalent rights. In other words, rights are a creation of the social state, and they are correlative to duties. And they have value and utility only within society. And by society, he means political society. And although he uses the term natural and imprescriptible in association with rights, so he sounds a little bit like Locke and a little bit like the Americans, he thinks that rights take form only through agreeing to a voluntary association which determines social relationships in the form of rights. And rights are imprescriptible, not in the sense dominant in America, as natural pre-social characteristics of the individual. They are imprescriptible in the sense that abolishing these rights means dissolving society, which recognizes them, and returning to a state of nature, where rights do not exist. It is the formation of the general will to which everybody contributes that defines those rights, and those who created society imposed upon themselves the duty to obey the law. They have naturally and imprescriptibly acquired the right to make their own laws and to determine the authority which executes them. So for Crenier, who follows Rousseau almost word by word on this point, liberty and equality, and in consequence life, security and happiness, are values whose protection is founded on the general will. So the general will is constituted in the state and society, and any law, even that which could be called natural law, has its foundation only in it and not in some order anterior to the state. And even those thinkers who discuss rights as natural, as I mentioned earlier, accept that it is society that favors and amplifies liberty. So Aristotelian teleological elements in the understanding of liberty were present in their discourse to the extent that they saw liberty as something which is to be perfected within society. Legislation enacted within political society only embellishes the existence and the liberty of man. So if liberty is understood in this way, then I think this can help us understand why it is legitimate for the government to regulate also the expression of ideas to a greater extent than it is the case in the US. It is legitimate for the government to limit hate speech in order to protect the persons that are attacked by it, but also the citizens more broadly from the danger of reaching erroneous opinions. And it is legitimate for the state to regulate also expenditures for political campaigns and provide rights of access to the media, as it is legitimate also to outlaw eccentric modes of self-expression. So it is this background understanding of the origins of liberty that has important implications, I think, concerning the acceptance of limitations on state authority in those two legal systems. And it has implications related to the legitimacy of the role of the law in defining the content of liberty and its limits. And so I engage in this discourse to show that maybe the US may be overprotecting freedom of speech in some respects, because this theory of natural rights is reflected in the relevant debates, and France may be underprotecting the same freedom, but understanding those ideologies does not necessarily mean accepting historical determinism. It is possible to think critically about just criteria for limiting speech. And principles and rules that were elaborated in the past in order to meet concrete sociopolitical needs may not be relevant today in order to address concerns that are related to limiting rights. So I engage with some of those case studies that I analyzed earlier, and I'm trying to propose to what extent government intervention is legitimized in order to limit speech or not. So it would be against, of course, headscarf bans and bans on idiosyncratic self-expression, but I would be in favor of limiting hate speech in some instances and regulating also political campaigns. So there are some interesting overlaps and themes that meet also Peter's presentation as to the definition of the forum internum and the forum externum. I think we can approach it also in reference to these subtle nuances of rights that I just described in those two legal contexts, because I think there's also there a difference as to the point of departure and how these different legal systems trace this line between forum externum and forum internum. But that's maybe something for us to discuss later on. So let's hear Talya's presentation now. So Talya Ucaryilmaz is a postdoctoral fellow at the University of Amsterdam, and she will talk to us about Laesio Enormis, from Byzantino-Roman law to the Ottoman Mecelle, a comparative study. Talya, please.
Thank you so much, Ioanna, and thanks everyone. It's an honor to be here. Can I share my screen?
Yes, please.
Yeah. Okay. Yeah. It's visible, right? Oh. Okay, so I would like to say that, first of all, my specialization is Roman law, comparative law, and law and economics. And to start with a caveat, I'm not an Ottoman law or Islamic law scholar, but I understand Ottoman Turkish, so it helps. I'm right now working on the changing role of traditional Romanist contract law and the postmodern lex mercatoria, and today I will talk about Laesio Enormis, gross disparity as a manifestation of contractual good faith. So in another word, a contractual, a relative right. I will compare its application in Roman law and in Ottoman Mecelle. This is a puzzle piece in my current research trajectory, and I aim to develop it further. I'm originally Turkish, so my story started in Anatolia, where both Corpus Juris Civilis and Mecelle was codified and applied. So I will try to question the tension between different legal traditions, which also fits the interdisciplinary character of the research as the history of law and history of economic ethics. So Roman law and Islamic law, of course, represent two totally different legal traditions. However, there are also many similarities that are firstly naked to the eye. A good example for me is Laesio Enormis, the gross disparity rule. This rule basically refers to the ability to rescind a contract if the price of exchange presents an obvious, unfair, and unreasonable disproportionality, disadvantage to the other party. So we see that this institution was also adopted in Mecelle, the Ottoman quasi-secular civil code of 19th century. And accordingly, the question lies on scrutinizing the Roman rules of Mecelle and mostly tracing down the universal role of gross disparity. So what was the Laesio Enormis in Roman law? Roman law, especially in the Republican era, focused on the free market idea. So buyers and sellers were free to agree on a certain price that was called pretium, and such micro-free markets reflected some sort of relative state of nature of the parties, and they were guided by their own self-interest. So accordingly, natural law stated that it was possible and it was acceptable for the parties to circumvenire, to overreach. And Roman contract law, of course, adopted certain measures to prevent this possible abuse of such agency. To me, one of them was bona fides, the objective good faith rule. It presented a standard of behavior for the contracting parties. It required acting in an honest, loyal, and reasonable manner in mostly commercial relationships, and also taking the legitimate interests of the other parties into consideration. It was the conceptual antonym of dolus, deceit, and also a requirement of equity. Yet it signified the trust between rivals. So it didn't necessitate the price to be fair or just. In the late empire, it's generally accepted that Diocletian issued two constitutions that set the rules concerning the just price, justum pretium, to restitute the balance between party performances for the first time. These rules are believed to be taken later on into Corpus Juris Civilis in the early Byzantine period. Accordingly, if the sale price of a plot of land was less than half of its fair price, the seller could rescind the sale because of gross disparity, whereas the buyer could save the contract by paying the remaining amount. So the fair price was generally understood as the market price. However, of course, the linguistic and systematic research also refers to possible interpolatio in those original texts. mostly Professor Helge argues that it's suitable for the tax policy of Justinianic era, where small farmers had to sell their lands for really low prices out of necessity. In any case, the constitutions, they were interpreted apart from the social and economic realities context of the Diocletian era to prevent antinomies in law. The late Byzantine law recognized the institution of Laesio Enormis, but applied it in a slightly different manner. In Basilicae, the rules were modified to include the sale contract for all goods, yet still only for the seller. However, the idea of the unreasonable gross imbalance may constitute dolus again dates back to classical bona fides, which was defined as the fundamentals of justice by Cicero. If the disproportionality was caused by the intent to deceive as its subjective element, classical Roman law gave praetorian remedies for the other parties, such as exceptio doli or restitutio in integrum. After the Byzantine period, the medieval legal scholarship adopted the classical rule in a wider form. So the inherent imbalance in a contractual relation was seen as dolus extra ipsa, being intrinsically fraudulent. So dolus was presumed in case of gross disproportionality. The classical term in that time, qui convenire, was changed to deceit, assuming profiting too much was per se dolus. Later, the rule was extended beyond immovable property and the class of sellers, and it became a general limitation. So was there the medieval doctrine of Laesio Enormis in Ottoman law? When we look at the late Ottoman law, centuries later, in the same geography, we face a similar situation. Article 356, for example, regulated gabnal fahish, the literal translation of Laesio Enormis. The article reads as follows: the existence of gross disparity in a sale, but without actual deceit, doesn't enable the person who has been the victim of such lesion to cancel the sale. So it demonstrated similarities with the classical Roman view, the freedom to determine the price in the sales contract and the prohibition of fraud. Parties may have avoided the contract in case of gross disparity between party performances caused by fraudulent behavior. Other articles in Mecelle also conformed with this liberal understanding of market economy. However, Mecelle also presented certain exceptions in sale and hire, only to protect minors, VACs, the public pious foundations, and the treasury from unprofitable transactions. These were the cases that involved legal agency, and law in that case imposed extra protection. Yet the ratio legis of the rule is again the protection of the weaker party. The protection of orphan minors is said to be central in Islamic thinking. One possibility argued by historians is that this rule has started in orphan minors and then later extended to treasury and to pious foundations for economic reasons. If we accept this premise, then we should say that Laesio Enormis in Mecelle is said to be rooted in Islamic thinking. Yet the same rules were applicable in Anatolia for centuries. Westbrook, following Kron, for example, proposes that the origin of the rule lies much further back in time in an ancient yet solid legal tradition. We have the letters of Assyrian and Akkadian merchants in Anatolia that show the rule was applicable as a recognized principle for millennials. On the other hand, the idea of protection of the weaker party was also compatible with the Republican era Roman law. In the classical era, the deafness, for example, of one party who was faced gross disparity was seen enough for presuming dolus. Another similarity is the arithmetic proportions, the media parts used in deciding on the existence of an excessive imbalance in both Roman law and in Ottoman Mecelle. For example, Article 165 states that Laesio Enormis is practiced with regard to no less than 1/20 in the case of movable merchandise, 1/10 in case of animals, and 1/5 in case of real property. The reason for this differentiation is also market demand. These proportions are said to go back to 12th century Hanafi scholars, one of the major sects in Islam, and also the dominating school of Mecelle. Possibly, they say Abu Hanifa or his disciples Abu Yusuf or Muhammad Shaybani was responsible for this idea. For example, Professor Yokish argues that Shaybani was familiar with Corpus Juris Civilis and was involved in its translation, although this is also disagreed by many historians. Yet he was also known to commonly use the analogy in legal science as a method. In any case, Mecelle seems to establish a balance between ethics and the requirements of the market, just like Rome. Also, in that case, this arithmetic proportion similarity, the Mesopotamian influence is also an option in this regard. Although there are technical differences, the fundamental idea behind is still fairness through the protection of the weaker party. In Ottoman civil law, Laesio Enormis didn't stand for an objective state of loss because of a bad bargain like the Diocletian era. Rather, it was closer to the classical Roman understanding where deceit was central. The exceptions also reflected the early Byzantine view. In Ottoman language, the term gabin is also used interchangeably with fraud and trickery. So the difference lies on which situations where the respective society couldn't tolerate the disproportionality according to its own social and economic context. Another question is, was Mecelle a response to modernity? To dig the Roman influence in Ottoman Mecelle, we should remember that it was the result of the legal, social, and economic changes within the late Ottoman Empire. In the atmosphere of legal pluralism, it aimed at reconciling the commercial needs of Muslim and non-Muslim communities and also the relationship with Western countries. Ottoman Mecelle operated as a jus commune in the Eastern Mediterranean for centuries. The idea of codification of the legal rules is not compatible with Islamic law. Just like Roman jus praetorium, it was case law, a juris-based system. Nonetheless, the articles of Mecelle were primarily based on late Hanafi jurisprudence and Islamic fiqh rules. Mecelle, however, was not a religious book. As openly stated in the Article 39, the terms of the code may have varied according to the change of time. So it was open to teleological interpretation to suit the contemporary commercial needs. The Romanist effect in Mecelle resulted with deviations from the authoritative character of Islamic law. It legitimized local practices of Byzantino-Roman world to make it a bit more well-equipped for different communities. It also minimized the religious ethics by being loyal to the binary code of legal and illegal. It was based on individualism, for example, absolute private property, freedom of contract, and so on. Accordingly, such effects can be examined in four main interdependent points that do not exclude each other. Firstly, Mecelle was strongly influenced by the French Code Napoleon of 1804. Article 356 was the reflection of the French article 1118. Before Mecelle, the prime minister of that time, Ali Pasha, proposed to adopt the French Code Napoleon directly, but that proposal was rejected. The Minister of Justice, on the other hand, successfully proposed to draft a new Ottoman civil code. Yet, we see that there is a clear French influence and also early modern natural law influence as well. Another puzzle piece is that Ottoman legal reforms at that time included the adoption of the French Code de commerce and French Code Penal as a system. Another major point is Ottoman Mecelle, of course, like everything, didn't appear ex nihilo. It was a result of a long judicial tradition at the same geography where Byzantine law and Roman provincial law were included in its legal cosmology. So also Ottoman Islam and classical traditions have been sharing customs, symbols, and stories since antiquity. The living law in these traditions are irrevocably combined. So the influence by the Eastern Mediterranean and Anatolian scholars in that regard can be seen crucial. There are many institutions in Islamic law first found in Byzantine provinces, and they are also carried by legal maxims and Islamic law principles, and for some scholars, they are seen as the Roman origins of Islamic law. To me, the main point is, however, the idea of commutative justice and fairness, because the Muslim jurists also had the similar concerns as Aristotle had, or Aquinas had, and therefore they came up with similar solutions to similar problems. Especially the Hanafi tradition was known to be more liberal and not standardized compared to other three major Islamic sects. That gave place to plurality of opinions, relatively. They relied on the concepts like people's interests, facilitating people's transactions, the Arabic translations of them, of course, taking the requirements of the time into consideration and considering customs and tradition. The synallagmatic contracts are inevitably considered from an Aristotelian lens, as their telos is fair exchange. As its extension, the institution of Laesio Enormis is a result of a commonsensical universal behavioral criteria based on economic considerations. So the idea of protecting the disadvantaged party for stimulating trust and stability in trade serves to efficiency purposes. In its deceit-centric version, it became the predominant idea of modern civil law, revolving around the newly emerging global trade and the idea of prudent and trustworthy merchants. The Ottoman Empire adopted the same principle to keep up with the economic relations. Just like Islamic law, modern Western traditions accepted the objective condition of Laesio Enormis as the disproportion between party performances and the subjective condition as the willingness, the intent to exploit the lack of knowledge, the lack of experience, or hardship. So basically, it's Mecelle, we can say that it's not the manifestation actually to manifestation of how Islamic jurisprudence responded to legal modernity. Rather, it shows how Islamic jurisprudence was also created by the Western legal tradition and vice versa, and how they have always been intricate. The gross disparity, as an example, evolved in Byzantium with Christianized ethics mixed with classical Roman rules and also Eastern Oriental effects. And both Mecelle and early modern Western world presents us right now with the change from the religious morality to commercial morality. So that would be it, and thank you very much. I'm looking forward to the feedback.
Excellent. Yes, there are very interesting links between your presentation and Helge. So you're discussing private law rights from the Roman era towards the formation of contemporary jurisprudence. I was discussing nuances within the philosophical discourse of modernity that bring it closer to antiquity, but mostly in the area of public law. And Peter also was expanding on ideas of public law and how the state itself forms liberties, even when it pretends to be secular, right? And defines what liberties we have. So maybe I see some comments here. Shall we read those and then see if the participants have some thought to contribute, and then we can start commenting on each other's presentations. So I see here a comment: should the concept democracy or sustainability be considered as contemporary concepts in comparative law? At what extent should rights jurisprudence adapt to concepts used in sociology? For example, capitalism, surveillance, risk, society, etc. Any thoughts on that?
Maybe you could elaborate a little bit on the question where you're coming from with it. And I'm always a bit hesitant to assume, a defined disciplinary space for comparative law. So it sounds almost as if you're thinking of this as a conceptual transfer somehow, but maybe you could elaborate a little bit more. It would be great.
Yeah, well, I'm just wondering what extent can we, as lawyers, as like thinking in not only regulating or using new concepts, but at what extent can we use the sociology concepts to our labor? I mean, for example, it's very trendy, to talk about sustainability, but people doesn't know, the meaning or how can we enforce these concepts, or to consider part of the law.
Mm-hmm.
Yeah.
Well, to me, comparative law or comparative legal studies is really a a big tent. And I think that comparative legal sociology, for example, or sustainability in environmental law and environmental studies, that this all should have its place also under a broadly understood comparative law. Again, I don't think there is something like a really real disciplinary cohesion in comparative law that would allow us to define clearly what falls under it, especially kind of a core of technical legal arguments. So I would be completely open to that.
Other thoughts in response to this question before we move on? So what you note about capitalism is actually relevant to the ideas I was discussing earlier on, because scholars have discussed this concept of varieties of capitalism, and let's say France and the US are two different variations of capitalism. And I discuss some of those ideas in other parts of my project. So to my sense, the state in France will engage in redistribution, will protect the citizens, let's say, will make sure that the citizens have the material preconditions to be able to exercise their liberty, and at the same time, it will go a little bit further and will limit opinions that are some sort of dangerous for the citizens. So states that have this where it is legitimate for the government to intervene and engage in redistribution, it's more likely that the state will intervene a little bit further in the world of ideas. So in that sense, capitalism is relevant. This variety of capitalism is relevant for my purposes. And this goes back also to what Helge was discussing earlier on, the reaction of governments to the current crisis. Right? I think there is an obvious difference between how many European states have reacted and the systems of support that they have provided for civil society compared to what the US did. So and this could be traced back also to the degree of legitimacy of the state to intervene within civil society and to engage in redistribution. Any thoughts on that? Or
I'm not sure I have anything useful to add to what you've both said. But maybe we'll take the next question.
Excellent. So, Marie Kim, I wonder whether there's a global trend for courts to abuse the public policy or the public reasoning to the detriment of accepted legal principles, shifting responsibility for a difficult decision.
Yeah, well, having heard Peter's presentation and also Helge's, I thought maybe the courts around the world are getting lazier and lazier. Instead of giving a legal reasoning, they just render a decision says on the basis of public policy. So I wonder what the other members of this panel think about that.
Yeah, I could certainly say something about that. I think the specific words that are used in the European jurisprudence are public order, which is slightly different to the ordre public as it's used, I think, in French law. So that's an important distinction, I think, because ordre public has a much more specific meaning when it's used, I think, to limit rights. But the one thing we observed in our work was that this notion of public order is becoming something that more and more courts are invoking to justify limitations on rights. And one of the results of that mode of reasoning, and it's very complex the way this actually works in the jurisprudence, but one of the obvious trends you see is that however the notion of public order is interpreted or constructed, it tends to incorporate or track very closely majoritarian norms and values. So, this is one of the sort of, again, the paradoxes of the modern state is that if you look at India, for example, there are all these claims of sort of Hindu majoritarianism overtaking the public sphere. If you look at some of the countries with Orthodox majority populations, you see similar kinds of trends. So it's quite a challenging phenomenon to observe that the notion of public order becomes a means by which there's a sort of dynamic connection between the public and the private, and what is demarcated as, in a sense, in the forum internum as intrinsically beyond state authority and power, that the state claims not to intervene in, actually ultimately becomes absorbed into and incorporated into the the notion of public order. So I wrote a long article on this, trying to make this argument in relation to the Sahin case in Turkey. And the way that the court deploys the notion of public order in Turkey to justify its limitation on the wearing of a headscarf by a medical student, I think you see this dynamic.
Yeah, so when we read the court decisions, you really are looking for some brilliant reasoning, but then you end up finding, oh, it's public order. Oh, fine, thank you.
There's a different, here there's a difference between European and American, North American courts, certainly. And it seems to me the European courts tend much more to rely on kind of a formulary approach, go back to the Cour de Cassation kinds of judgments. And whatever you think about American constitutional decisions, you can't accuse them of being too reticent. I mean, they go on at great length, so that this is an interesting distinction between it. And it certainly does, as Peter said, it certainly has a dangerous implications for the protection of rights. And the European Court of Human Rights is just as guilty of this as anybody, maybe more so.
Yes,
Please, now, from also a continental perspective, I think it's the inevitable destiny of those ambiguous legal principles, because it's kind of instrumentalized to just justify your reasoning. When they ask, if I'm not mistaken, it was hearing, and when they ask, what is public order? You always use public order. And you said, you cannot explain it. You have to live that. You have to inhale that. So the normative phenomenal elements that make these concepts like public order, good faith, and in continental tradition, it generally comes also with public interest. They are indefinite, so they are filled with extra legal social dynamics. And that's why it's inevitable to end up with such concerns, I think, at least from a continental point of view.
And in France, around at the moment of the debates around the banning of the burqa, the facial covering, the concept of immaterial public order emerged a lot. Right, and it was used. It was the context. It was the concept through which the state actually defined, right, what is part of the forum internum or the forum internum. So covering your face is considered to be an acceptable, right, way of manifesting your religiosity. Yeah.
I might just add just one footnote to Richard's comment in the US. The one place I've tracked this argument in US law, which, as you say, follows different trajectories, is the attempts in various state constitutions to make the invocation of Sharia law in the US unconstitutional. And often you hear these arguments that even the invocation of Sharia would be a threat to public order. Yeah.
Maybe one final thought. Hi, Marie. Nice to see you. That when we see this increase in bringing political questions to the courts and trying to resolve them through rights jurisprudence, I think it is the almost inescapable, inevitable flip side that we will find not rule-guided decisions, but decisions that are based in broad balancing, right? And I think, Rick, that's absolutely right what you're saying. I think the cultural difference here is quite interesting. Of course, then all you have in terms of guiding judges through their decision and kind of maintaining some sort of tethering through rule of law aspirations is to force them to explain themselves, right? And to force them into some sort of transparent reasoning. And that is, of course, something that we see much more in the Anglo-American tradition than in the at least French continental tradition, right? What else is there than actually laying the cards on the table and saying what it is that's guiding your decision? And in that case, I don't think that this is lazy, right? Lazy is really the withdrawing from making decisions. And as a historian, what comes to mind from this continental perspective, as a historical discussion in Germany, what it was that made German jurists so well trained, right, to fall from grace. And there was this argument post World War II, it was their formalism, it was their soulless adherence to the rules. And the counter argument was no, it was actually the fact that they gave up trying to make rule-bound decisions, but relied on these open-ended rules, the flight in the general clauses. And it's true, if you look at the cases, you see that it is at this point that the judges gave up not their belief in rules, but then their belief in the rule of law, where they found empowered by these general clauses to just bring in all these perverse Nazi standards of adjudication. And this is the moment where they really cut the tie and remove themselves from what the legal profession should be about. And in that respect, I think that's the moment we have to focus on. That's when the laziness becomes dangerous, right?
On that subject, before you go, that if you read Vivian Curran's article, you know that Helge on the difference in German and French judges before the war, very revealing.
Yeah, exactly.
Ioanna, I think Francisca had a question.
Please, Francisca.
Hi, I have a comment for Helge, I think, and then a question for both Helge and Ioanna, basically, and maybe the others. Helge, I think it is very important that you write this book. We are over, and why? Because when I see, contemporary criticisms of rights, especially from post-structuralism, from critical race theory, for instance, from LGBTQ plus rights criticisms, sometimes I have the sensation that some of the participants in these criticisms believe they are the first ones to do a criticism of rights. You know what I mean? And you are right, and it's true that this is an iteration, a historic iteration, and the criticism of rights is as old as right theorizations, and we have Marx, we have even before many things. So I think it's important for contemporary rights debates to have this longue durée, you know what I mean, kind of alternation between rights criticism and rights vindication. And learn what you've said is so interesting that, the totalitarianisms in Europe, come after precisely a stage of very hard rights criticisms, in which even Kelsen participated.
Right.
So, and you even could do, comparative, diachronic comparative theory, you know what I mean? And what is different from contemporary criticisms of rights from the criticisms of the 19th century. So as a comparatist, you could do that historically. That would be extremely interesting, right? So I think this is important. And then let me, I don't know about the time, let me put the question and then, but the question is there a way, Helge, of doing this without, what do you want to do? And especially because you want to compare things in Germany, in France, and the UK, you said. Is there a way to do this that does not rely on the state as the central explanation for what's different in different legal evolutions? Because I think this is a problem, for instance, in the construction of the subjective rights in German 19th century public law scholarship, von Gerber, Otto Meyer, all these guys, that, it's always explained that they created this theory of subjective rights because they wanted to secure areas of freedom in front of an authoritarian state, because Germany at that time was still a very authoritarian state, not a democratic state. So all what I see all around this, always take the role of the state as the central explanatory element. And Ioanna, when in your story about what's different in France, whatever, also the role of the state and conceptions of the state, and in comparing, you know, the role of the state in the US as compared to the role of the state in you know, welfare state Europe. And I think Francisco had maybe that discomfort in the question that raised on the chat and then afterwards, because when we do contemporary rights arguments and contemporary rights theory, we are interdisciplinary and we go, you know, to many, and when we do these sort of operations that you are doing here, as legal scholars, because Helge, I agree with you, there must be a properly legal story told in this, and not only, you know, historians or I think we resort to the state inevitably, and maybe this is impoverishing, you know what I mean? We should be maybe capable of saying something from the law, but that does not dialogue only, explains things only by the role of the state. We are beyond a state-centric paradigm in law today. And yet much of what we do in comparative terms and in historic, you know, evolution of now rights theory puts the state on the center. I don't know, that's what I think could be like debated.
Should I try to respond? Or Peter, Ioanna, do you want to go first? I mean, there was a lot in there, Francisca, and I can tell this is not your first rodeo when it comes to thinking about these questions. So maybe we should have a conversation outside of the limits of this little panel here. Well, so. Well, thank you. I'll try to write this book. I've written a couple of articles, some of them in German, unfortunately, so I couldn't really offer them to the audience here as background reading. But yeah, I'll tell my 6-year-old son that I need to write this book. He's the main reason. So take a little longer. Yes. So let me start maybe with the state framework. Now, yesterday I just talked about how we shouldn't think in terms of state and how it's a paradigm that needs to be challenged. I think if we historicize the question, we have to factor the state in, though, as a powerful paradigm that shaped the way that thought, especially in law, was formed in this particular period, right? And I do think, or I tried to do this in the book by taking a little bit of a removed observer position here, in taking a more sociological perspective, if you will, on discipline formation. So really looking at who are the people who are thinking about this, what is their approach to their task and their job within this newly forming university, and in how far is their thinking restrained by this new sense of the nation state being the be all and end all of thinking at the time, right? And it's undeniable that there is a limitation, particularly at the time in which a discourse that was happening in Europe before this focus on the nation state is impoverished in this time, where we have a natural law discourse, we have a discourse of jus commune that was not completely, but to a certain degree, transnational, and that at the time really shrinks when legal science in the university setting is reconceived of not as, you know, philosophy of law, but really as a science of positive law, and the ties are being cut with philosophy as a university discipline. So I've worked quite a bit on this moment where natural law thinking and becomes political philosophy and legal philosophy that is being done at philosophy departments, whereas legal thought really has to focus on the positive law and the nation state in order to be relevant, in order to find disciplinary identity, and that only towards the end of the 19th century, there's something like a positive philosophy of law or a legal theory that springs up from this new restrained academic turf, if you will. And in this context, we see how the theoretical approaches are so intellectually limited. Yeah, and when the scholars you named are not looking anymore outside of this national framework. And despite the fact that we're, of course, now coming back with this transnational perspective, we have to really take into account how national cultures of legal thought, of legal philosophy, come into being during this particular period. And although we don't like it, do persist. Right, we've just heard about the topic for a meeting that will be comparative law. Different styles of comparative law exist still in different systems of legal education. So does legal philosophy, legal theory, and I think in that respect it's justified to maintain this framework of the nation state because it is a historicized view of the topic, and the challenge is indeed for that book project to still then challenge this established narrative that is, of course, coming out of this very development as a self-portrayal, basically, of the project, the historical project, that is, we're creating rights as a defense against the state, right? Rights are harmless, rights protect the citizen. And I've tried this in the theoretical part of the book by engaging with the counter narrative, and that is that rights, of course, come also from a tradition of dominion, of domination, right? Where we see freedom in the Lockean tradition as self-ownership, as self-domination. And then the parallel between subjective rights and sovereignty becomes obvious, and also the part that power over, that domination, that force plays. And those are the papers I wrote in German. I had the chance to engage with the argument by Christoph Menke, that is kind of second generation Frankfurt School. He's written a book on rights, and we had a chance to engage in a dialogue there, which was fantastic. Because he theorizes law as violence, Walter Benjamin and all that. And I think that is something that plays a role in the history of rights as well, but it is completely eclipsed by this official story of we're just defending citizen rights, and when now citizen rights are defended with assault rifles, I think this has also a very current and topical illustration, right? How do you understand this individual domain? Is that something that is tied to Republican standards of citizenship, or is this really that I'm the master in my bubble and I can defend this to the death if need be, right? And I think those are, again, exactly the cultural differences that comparative work is interested in. So thanks so much.
I'm not sure how much time we have, Ioanna, but
we have exceeded our time, but if you're willing to stay, I'm happy. I'm happy to stay also, because the questions are terrific. So Siska, a very brief response. So I think, yeah, in relation to the role of the state, I would have the same response that Helge just gave, and I wouldn't give it in such an elaborate way. I would just say that since I am studying a legal difference between different states, it would make sense for me to look into the different ideologies and philosophies on the role of the government. To a great extent, even those differences fade, right? So in France, also the protection of freedom of expression expands, but very frequently also we see a reaffirmation of those dominant ideas every now and then, right? And I think the most characteristic example is the legislation that was enacted recently by the Macron government, which allows someone during a political campaign to bring an application before an urgent applications judge and ask this judge to order the removal from the internet any information that the judge thinks is fake news. Right, so see, to my sense, this is an extensive government intervention, and it can be understood from this broader perspective. And also Marx and his critique of rights, which to which you referred earlier on, and Helge also mentioned him earlier. So Marx is an amazing thinker, but I think he got it right. He got the French Revolution. He didn't get it entirely right, let's say. And his critique was not entirely justified, and his criticism of the abstraction of the citizen and the man in Rousseau may be a little unfair towards Rousseau as well, and towards what the French revolutionaries were trying to do. And there are many historians that have provided interpretation as to why he polarized. He adopted this extreme interpretation of the French Declaration of Rights and the various French declarations of rights. He wanted to present the French Revolution as a bourgeois revolution, which failed, in order to make a case that there is proletarian revolution arriving later on. So, but yeah, let's just, for the purpose of this discussion, keep the fact that maybe the debates were much more nuanced than what he's trying to present in the Jewish question.
So if I could just make a response to Francisca, it's a great question, and it's something I've thought a lot about as well. Of course, once you in the sort of world of the human rights literature, the question of the state is of course really very interesting. I loved your point about the sort of longue durée of critiques of rights. In the project that I was describing, we really did try to take a view, a global view in the true sense, as not focusing on any particular state or any particular type of legal structures. And I guess it came somewhat as a surprise, in a sense, to see the uncritical way in which rights discourse was being articulated and the kind of reasoning that was being used, right? So it was interesting to me that there's so much more criticism, I think, that needs to be deployed. A more critical view needs to be deployed about the kind of global pretensions of much rights discourse today. And I think that's quite interesting, that view as well.
Excellent. Do we have any other thoughts, questions, comments, anything? No?
Maybe this
Okay,
one.
excellent. Thank you very much. What a wonderful discussion.
Yeah.
Thank you.
This is a kind of event which makes you unhappy that you can't carry things on over dinner or over coffee.
Exactly.
Thanks a lot, Ioanna.
Thanks,
I'm
very
really
interesting.
looking forward to the conference next year in order to make up for what we missed this year.
For sure. Night.
Thank you.
Thank you very much. Great to meet everybody.
Thank you. Great to
Thanks
meet
so
you.
much. Bye-bye.
Can I say hello to your son, Helge?
Yes, Marie, here. That's Leander. Say hello. Say hi to everyone. Be nice.
Hi.
Hi. Thank you. Thank you for being understanding about this. Appreciate it.
Thank you.
Of course.
I'll catch up with
Dad got his new bike seat.
Oh my God. This is being recorded for posterity. So, okay.
So as hosts, we have the possibility to end meeting for all, to leave meeting. What do we do? Shall I end it for all? Shall I be the radical one?
Once we're all,
Bye-bye.
Yes, once we're all
Bye.
left, there
Nice
will
to
be-
meet
that's what it. Nice to meet you, Talya.
Likewise.
Take
Bye-bye.
care. Bye. Bye, Ioanna.
Bye. Thank you again.
We should also talk more about rights stuff.
Absolutely.
No,
Yes.
the manuscript, of course. So I think there's a lot of overlap. We should
Bike
talk.
seat.
Yes. Okay. Take care.
Bye.
Thank you. Bye.